Afternoon. My name is David Gallo. I'm the director of the AIFC Academy of Law. We'd like to welcome all of our guests from across the world who have joined us today for this highly interesting webinar discussion today on the topic of professional ethics in the legal profession. The Academy of Law is dedicated to preparing lawyers for international commercial law practice. As most of you know by now, we are an English language common law jurisdiction operating in a surrounding environment of civil law jurisdictions, but the multiple jurisdictions work hand in hand. They work interdependently. So part of our mission is to do what we can to make sure that we are, if you will, maybe filling some gaps in traditional legal education by focusing on cross-system training, both substantively as well as imparting skills development type of programs to truly enable you all to operate effectively in an increasingly complex international legal jurisdiction. And just a couple of housekeeping matters. You all have a chat function, and at the end of the session, we will be paying attention to your written questions that you may like to send over to us, and the speakers will go ahead and respond to those questions. Today's event will be for about 1 hour, and it will be somewhat of a dialogue between a couple of experts who are with us today. With that, I would like to turn the floor over to Professor Alexander Van de Putte, who will formally introduce today's activities and the speakers. At the AIFC, Professor Alexander Van de Putte is the chairman of the Academic Council of the Academy of Law. He is the chief strategy officer, and he's the chairman of corporate governance and stewardship. At IE Business School, one of Europe's leading business schools, he is a professor of strategy and strategic foresight. And Alexander Van de Putte is a friend and a colleague, and frankly, one of the most impressive individuals I have ever met under any circumstances. So with that, please, Alexander.
David, thank you very much for the introduction. People that see me on the camera will now notice that my cheeks are red because of your nice compliments. But indeed, David is a very good friend. Now, I have the privilege indeed to introduce the topic and also our speakers. And as David mentioned, before the start of the webinar, it's really going to be a dialogue. And I really like dialogues, the Davos debate. I used to work at the World Economic Forum, and the dialogue actually really helps to move the agenda forward, especially if we can also include the audience, and this has been enabled with the chat function. So today we're going to talk about ethical principles in common law jurisdictions. You may know that the AIFC, first of all, is a common law jurisdiction, as David has referred to, but also has recently developed its ethics code. Now that ethics code will become available after Astana Finance Days, and more specifically after our Management Council, which is our high-level board, and that will be towards the mid of July. Now, obviously, ethics is important not only for the legal profession, but in general for the AIFC in order to build trust among the business community, especially the business community from abroad. Now, my pleasure is obviously to introduce our two speakers today. One is the moderator, the other one is a speaker. So let me start with the moderator. His name is Chris Kenny, and they're obviously both affiliated with the AIFC, but Chris Kenny in his capacity as chairman of the AIFC Advisory Panel on Legal Regulatory Matters. Now, Ian Miller, who is a partner at Kingsley Napley LLP, which is a leading law firm, he's also, I'm not going to read his entire CV, but I thought what was particularly noteworthy mentioning, given the topic of today, that he is an advisory board member of UCL's, that's University College London, Center for Ethics and Law Review. Now, that's one of the preeminent centers on ethics and law, not just in the United Kingdom, but even in the world. So I'm now going to hand over to Chris Kenny, but also to Ian Miller, and I will put my microphone on mute and follow the debate. Enjoy. Thank you.
Alexander, thank you very much for that introduction. And I will pass very quickly to Ian, who deserves all the compliments you gave him, and not only is doing a lot of academic roles, but it has just stood down as chairman of the Association of Regulatory and Disciplinary Lawyers in England and Wales, which is the core practitioner body dealing not with ethical matters at a theoretical level, but absolutely how they arise in practice and how regulators interpret them. And both regulators themselves and those facing trouble with regulators often turn to Ian to help them with their more complicated problems. We're going to divide his presentation in two. He's going to set off talking about some of the general issues. We'll pause there and have a brief conversation, then turn to some specifics. And at that stage, I'm hoping lots of you will have raised questions on the chat, which I can put to him, and we will keep the discussion going for some time, I hope. So without more ado, Ian, over to you.
Great, thank you, Chris. And well, first, thank you to the AIFC for and the Academy for giving me the opportunity to sound off in relation to sort of one of my favourite subjects. And when I was first approached to do this talk, it was suggested that I did something about legal regulation and ethics in England and Wales, and it seemed to me that was too narrow given the context of the AIFC. As has already been referred to, I sit on the advisory panel on legal regulatory matters. The AIFC is obviously a common law jurisdiction, as has already been referred to, and certainly what part of our work on the legal regulatory affairs aspect is thinking about how lawyers might be regulated as they work within the AIFC. And a big and in a sense determinative feature of that is the common law nature of the AIFC and how it will fit in with the way regulation within common law jurisdictions occurs throughout the world. So I started with I start with a slide of much of which may well be familiar to you, but examples of different jurisdictions around the world who are common law. Many of you will be aware it's effectively an English concept that through various things, not least colonialism, has broadened out most notably to places like the United States, and is certainly the dominant commercial legal framework used throughout the world. And has created a sort of quite rich tapestry of different jurisdictions who all have slightly different features, slightly different interrelationships in terms of the various concepts I'll go on to talk about, but all come back to some basic essentials. And certainly when we within our work around legal regulation, we'll draw upon those principles to think about how it might work within the AIFC. And so what I thought it might be quite interesting to do is to just look at the drivers that sit behind the ethical principles, and then a few of the ethical principles to explain why they are the way they are, and perhaps give those on the call a bit of an introduction. Some of them will probably find it familiar as to the types of issues that are likely to become more prominent within the legal community within the AIFC. So what is, in a sense, what is the common law is probably a several hour talk beyond today. But and I've also headed up this slide, common features, because there are differences within the balance within individual jurisdictions. So and some have historical variations. For example, in Canada, Quebec was historically a civil law jurisdiction and still has a very strong civil law framework within that province, but the rest of Canada is much more sort of primarily common law. But the essence, and many of you will know this already, of common law is that the law, or a large part of the law, is declared by judges and developed through custom and precedent. There are, of course, statutory provisions in all of those jurisdictions as well, but it's that idea of a decision being used as the basis for another decision on where similar facts arise, that's the concept of precedent that's very important in the common law jurisdiction. The other feature is adversarial dispute resolution. So in civil law jurisdictions, generally there's an inquisitorial process whereby someone or the judge makes inquiries of the parties in order to come to a decision. But in the common law jurisdiction, the parties effectively fight it out in front of the judge, who, having heard both sides of the argument, decides which side's version of the law he prefers, or he or she prefers. And it's that adversarial element, which I'll come back to again, but is what makes lawyers so important in a common law jurisdiction. Because if a judge has to decide which argument they prefer of two that are being advanced in front of them, that only works, and indeed have to determine facts in order to get onto the law, that only works if the lawyers have duties to the court to tell them all the information they need to know to make the decision, and to provide them with all the relevant evidence in order to make that decision. The system literally does not work if lawyers withhold information, don't tell judges about relevant cases that they need to consider. And that features not only in the decision of that particular case, but also in if that case then forms a precedent and then goes on to develop further law, the whole common law system falls down without the proper behaviour of lawyers within the administration of justice. And that is a crucial feature which I'll certainly come on to and develop in a minute. And then finally, there is generally the independence of the judiciary and the court system from the state. Again, it varies from country to country, but the idea that judges are independent, but also the lawyers that they that serve them are independent of the state is an important element of the way the whole system works. So why do we have ethical principles? In a sense, that's answered by the previous slide, because the ethical principles on lawyers are an essential part of the running of common law jurisdictions. So there therefore needs to be a framework and a set of rules that enables the system to work, and quite a lot of those principles are then found in the codes of conduct of the lawyers in those jurisdictions. And at a very high level, they have sort of three elements to it. It's serving the interests of consumers of legal services. That's a modern way of putting acting in your client's best interests. So self-evidently, a lawyer needs to look after their client's interests, and I'll come back to that in more detail. Acting in the interests of justice, as I've already emphasized, is hugely important in terms of making the whole system work. So one of the dilemmas, which is sort of quite clearly decided within the jurisdiction, is if your client wants you to do something, like tell a judge something that's not true, but you have a duty to act in the interests of justice, where do you reconcile those two things? And I'll come on to that in a minute. And then, of course, there's a wider need for lawyers to act with integrity and honesty, because if lawyers are not trusted within the system, not just by the judges, but also by clients and those who rely upon the system, then the reputation of the system is undermined, and the ability of the system to function is undermined. So those three central principles of ethical behaviour, I think, certainly, as I suspect Chris and I and others on the panel will come on to start formulating a code of conduct for lawyers operating within the AIFC, and you can expect to see that those three principles will A, be prominent, but B, will guide quite a lot of the issues that arise of the behaviours expected of those that are operating within the AIFC, which come from, as I said, those wider common law principles. And then finally, I was going to turn to, and I think Chris and I are going to have a bit of a chat before I get to it, but to look at in more detail two aspects of legal ethics. One is the duty to the court, which I've obviously mentioned, and also the fiduciary duties owed to clients, that obligation to act in your client's best interests, to effectively almost put your client's interests ahead of your own, and how that particularly manifests itself in relation to confidentiality and conflicts of interest. Is that a moment to pause, Chris? You're on mute.
I have failed the main test of good moderation. First hurdle, I apologise for that. There were two things which we thought we might just explore here. You've set out, if you like, the theoretical background. There are two moments when all ethical principles, I suppose, can come under pressure. We'll maybe take each of them in turn. The first, just linking back to one of the themes we've been exploring in all of these talks, are the current circumstance where you have a worldwide emergency caused by COVID-19, all kinds of accepted norms of the way business gets done are having to be altered. A lot of organisations are getting more creative, but are also having to cut corners. How far do you think that what we're talking about with ethics here really works in a time of extreme pressure, or can judges looking at the matter, regulators looking at the matter, take into account levels of disruption and maybe allow standards to be maybe not quite what they would be in ideal circumstances?
And that, I mean, in a sense, that raises one of the beauties of a common law system is it's flexible around certainly judicial decision making in relation to circumstances. Another aspect, certainly, of ethical principles is they reflect society's values as a whole. There's a quite prominent solicitor in England who wrote about certainly the conduct of solicitors back in the 1960s, and one of the things he said at the beginning of his book is what is acceptable for one generation may be wholly unacceptable to the next, and that effectively all of this evolves and changes. So, for example, client money or fiduciary accounts, in holding client money 100 years ago, it was perfectly acceptable to mingle that money with the lawyer's money, and nobody thought that was a problem. But now there's a necessity in most jurisdictions to have separate accounts and properly account for it. And more recently, issues such as sort of sexual misconduct and bullying, which would have been thought 50 years ago or even possibly 10 or 20 years ago was nothing to do with ethical behaviour, have become much more prominent in debates around ethics. So, and I think that in the COVID context brings us back to, whilst all of those are examples of, I suppose, the regulation or the ethics becoming more rigorous, you can't be, you're expected to do your best, but if the circumstances that we all find ourselves in mean that we have to adapt and modify, then the system has to flex in order to reflect that. So I would expect that there will be cases that will come out of this, and my anticipation is that either the regulators or the law societies or bar associations will take a sympathetic line in relation to ethical dilemmas that have arisen out of the COVID-19 thing. But yeah, I mean, for me, it's a quite fascinating thing as I sort of sit in my spare bedroom working on a daily basis, no idea what's going on in the rest of the world or what issues and dilemmas are now being faced, that in a year or two's time we'll all be thinking, well, that's an interesting point, because it's all new.
And I think the core is then about self-reflective practice, isn't it? Because it's a lot easier to flex where you've got a huge amount of rules, because rules can always be varied in circumstances. But you've always got to remember as well that public confidence and client confidence depends on the core principles always being respected. And if anything, the ethical imperative to abide by the core principles is higher at a time of crisis than it would be in normal circumstances. So there are areas where you can give and areas where you really shouldn't.
Yeah. And I think, I mean, one of the issues that certainly I've had various discussions about is because everybody is now, well, in a sense, it's coming back to, it's closer to normality in some jurisdictions, but because people are working isolated in their own homes and not necessarily having the ability to chat things through with colleagues and identify issues through traditional processes, is there enough support for lawyers, particularly more junior lawyers, around ethical dilemmas and issues that they might arise where previously they could ask the person they share a room with, or at least who's somewhere in the same building, and now they have to make a telephone call, make a Skype call, whatever it is, and you're not sure whether that person's free, and it's a lot more difficult. And those issues are very real and practical, I think, for a lot of law firms throughout the world.
I think that's right, and quite often your colleagues will be the first people you turn to. Second issue I wanted to raise with you, though, is what happens if they're the source of the problem? Because lawyers will worry about what a judge thinks, they'll worry about what their client thinks, but they'll also be worried about what their boss thinks. And how far can we talk about legal ethics just in the context of individual behaviour? How far do we have to talk about it in terms of the behaviour and culture of firms and other organisations?
Well, very much so. And I think it's, to me, ethics and culture are completely intertwined. So if a law firm has a culture that is toxic, encourages bad behaviours, that will infect those that work within it, and that will lead to ethical breaches. Conversely, a good positive culture will minimise the risk of ethical breaches and encourage those who've joined the firm to behave in a certain way. So it's then quite interesting where you get, in some jurisdictions, there's regulation of the law firm as well as the individuals. So there is an ability through the regulatory framework to highlight culture as an issue that firms ought to think about. But in other jurisdictions, most notably the US, the regulation is entirely of individuals. So firms, for their own reputational reasons and quality and client service reasons, will obviously encourage a good culture, but there's no regulatory framework around the firm, say for possibly their insurers, because it's all individual based. And that's one of the great dilemmas of legal services regulation at the moment is, do you regulate the individual and the entity? What are the advantages of regulating the entity, and how do you improve culture?
And we'll maybe pick that up in fuller discussion at the end. We've started getting some questions coming in. One I'll give you advance notice of, Ian, which we might turn to at the end rather than now, which is how far the principles we're going to talk about work in a world of legal tech and artificial intelligence, or need to really flex and get into whole new areas. So let's store that one up for later. But maybe as you turn back to your presentation, one question from Arman, who's at CASGUU University, just talking about the source of ethical standards, whether they're determined by statutory instruments in non-statutory ways, where do they come from generally?
Well, I mean, the irony, or perhaps the inevitability, is that they are common law in their nature. So every common law jurisdiction's legal regulator, be that a state bar association of states or in individual in other jurisdictions, will have a code of conduct. But that code of conduct will generally reflect decisions taken, ethical decisions taken either by courts or regulators or bar associations or law societies over the years. So in a sense, the code doesn't necessarily direct the decision making. It reflects decisions that have been taken, but then influences decisions made in the future. So there's a sort of a symbiotic relationship between codes and decisions as they're made, and quite often, if a decision is made, a code might be changed to reflect it. So I mean, it started off, I think, as a series of ethical principles handed down without ever being written down, and then has evolved into most jurisdictions thinking it'd be quite good to have a code so that everybody at least has a high level understanding as to what's going on.
Right, I'll ask you one last one actually before letting you go back to the slide, because it's relevant to the earlier discussion. This has come in from, forgive me if I pronounce your name wrongly, Kuanish Kamitov, manager at CCLP, who asked the nasty question about legal tech, which we'll come back to. Talked about conflict, not simply boss and junior lawyer, but in relation to an in-house lawyer, where perhaps a code of conduct for a more general firm rather than a law firm would point you in a different direction to legal ethics. If you've got inconsistencies between employer expectations on a staff member who's legally qualified rather within a law firm, which would, how do you resolve that kind of conflict?
Well, you're tempting me down a very, very long answer, but I'll try and keep it short in the sense of another fascinating area of ethical behaviours is the position of an in-house lawyer who only has one client, which is also their employer. So traditional legal practice, normally a lawyer would have multiple clients, and if one particularly wanted them to do something they weren't very happy about, they have a sufficient level of economic independence to disagree. But what happens in the in-house context of your employer wants you to do something that you don't agree with and you think is unethical, you are left in the dilemma of, do I want to either resign or put my job at risk by not doing what my employer wants me to do? And that's there's been quite a lot of academic writing around it, and that is a very difficult scenario as to what is the best way to behave, and do regulators give in-house lawyers sufficient support to enable them to fulfill their role properly? Equally, there are some, certainly civil law jurisdictions, that don't recognise in-house lawyers as being lawyers in the sense of having legal professional privilege, etc., because of that lack of independence. So it is a fascinating and interesting and complicated area to which there is no simple answer.
It is, and something which one of your former colleagues at UCL, now at the University of Exeter, Richard Moorhead, has given a lot of thought to looking at the behaviour of some in-house lawyers at the time of the financial crash in 2008, looking at how far some in-house lawyers were able to assert legal autonomy in order to keep their clients on the straight and narrow, the extent to which some were perhaps pushed too far down into representing their client's interest, but in a way which didn't necessarily help their client in the long term if it actually compromised their own ethical integrity and their own brand. So, as you say, it is something we could turn into a lecture in its own right. I think I'd better let you go back to the slide.
Yes, I was going to say, you were almost tempting me into a further longer reply, and I'll avoid it. So the second part of this, I just wanted to touch upon two of those big ethical principles. There are others. I mean, I just touched upon one, which is the need to be independent of your client, to be able to give objective advice. There's the acting with integrity, upholding the reputation of the profession. So there are other principles, but the two that I think are if not the most important, the most central to quite a lot of issues are the duty to the court and the fiduciary duties of confidentiality and conflict. And I hinted earlier, and I just, without necessarily giving the answer, around that central dilemma of if your client wants you to lie to the court because that's in the client's best interests, and you have to act in your client's best interests, but your job is to uphold the administration of justice, and therefore you've got to ensure that the system works properly. Where do your duties lie? And certainly, I've put up a quote from one of the number of cases in different jurisdictions which make it abundantly clear that your duty to the court overrides your duty to the client. That you've obviously got to put the arguments in the best way for your client, but you can't go so far as to mislead a court or withhold relevant information from a court. And I'll come on to a couple of examples of that in a minute. Well, in fact, my next slides are a couple of examples of that principle in practice. The first is McCabe and BAT, which was an Australian case, which certainly was hugely prominent in Australia in the beginning of the last decade. So a lot of the tobacco companies from about the 1980s onwards realized that they were going to get sued by their customers for effectively the damage that long-term smoking had caused to them. And the basis of the claims, and they happened in lots of different jurisdictions, was you tobacco companies knew from a very early stage that this was harmful to me, but all you ever did is advertise it with lots of pretty flowers and sunny fields, and in some cases actually suggesting it was healthy, and you deliberately misled me, caused me to become addicted, and now I'm in latter stages of cancer, and that is I'm entitled to sue you for damages. So one of those types of cases was in Australia, and BAT, being a prominent and large tobacco company, had instructed solicitors there to deal with them, a quite large prominent firm. And when one particular claim by Mrs. McCabe came to trial, it became apparent that the firm had, over the course of quite an extended period of time, undertaken a number of strategies that helped the tobacco company in terms of managing the documents in the case, particularly those sort of early documents that might demonstrate awareness within the tobacco company of the health risks associated with tobacco. So they'd, as far back as 1985, had helped the company with a document destruction policy, which ostensibly was simply a sort of housekeeping exercise of making sure that they only kept documents they needed to keep, but had the effect of destroying documents that might have otherwise been relevant in the litigation. They were then found to have misled the court as to what had actually happened with documents. And then the third thing that they did is they'd sent some of the documents to third parties offshore, where they didn't know whether they might be helpful or relevant at all. So they weren't in the possession of the party to the litigation, so they didn't have an obligation to disclose them. But should there be anything helpful there, they could go and look, and if they found it, then they could sort of bring it back in within the company and then disclose it. So you could I mean, there's a very good example of in the administration of justice, a judge deciding upon Mrs. McCabe's claim needs to have all the relevant documents, certainly from the tobacco company in this case, to decide what it knew and when it knew it, and what it was saying to the public and how it was advertising its products over a long period of time. And if if the judge didn't have that information, then they couldn't make the right decision in the public interest and serve the administration of justice. So adverse orders were made against the client. From memory, basically the defence was struck out and she got judgment against them, and then there were, from memory, I think, disciplinary proceedings against the lawyers concerned. There was another example I was just going to touch upon, which is an English example of a in-house lawyer, which comes back to the earlier point, who acted for or worked for News International, which is a big press publication company, and they were, or one of their newspapers was quite interested in a blogger who was a police employee who would anonymously blog under the name of Nightjack about police practices. And they wanted to find out who the blogger was and reveal him as a press story. In order to establish his identity, they used unlawful means of identifying him, such as phone tapping and the like. But having established who he was, they were then able to retrace their steps lawfully and work out by lawful means who he was. In a sense, it's easy to find anything if you've got a map, and therefore they knew his identity by that route. So they were going to publish the story. The anonymous blogger sought an injunction from the court to prevent publication, and if he was able to establish that they discovered that information unlawfully, he'd be entitled to his injunction. But if they'd have found the information lawfully, he couldn't get his injunction. And in the course of the proceedings, the case put on behalf of the newspaper on the injunction was, we found this information lawfully. They didn't mention that they'd also used unlawful means. And the in-house lawyer for the company was in court at the time, and knew the full picture, but allowed the court to be misled as to the position, so the injunction wasn't granted and the story was published. Subsequently, he was the subject of disciplinary proceedings, and from memory, I think was suspended for a period of time on the basis that his actions had undermined the administration of justice by allowing the court to be misled as to what the true position was. So there's a couple of sort of duty to the court examples. If I can then move on to the fiduciary duties of conflict of interest and confidentiality. And what sits above those is a whole body of law around fiduciary duties, which is certainly in many common law jurisdictions, a term of art to describe a relationship of trust and confidence and in a sense reliance. So it not only applies to lawyers and their clients, it applies to trustees of trusts and their beneficiaries and other types of relationships where you have to in effect act in the best interest of the other party. So the obligations are to be loyal, not to have a conflict of interest, to maintain confidentiality, and communicate with candor, so give them all the relevant information they need to make decisions, and in a sense be open and frank in all senses with them. So that's the overarching fiduciary duty, but it manifests itself in two very tricky ways for lawyers. The first is confidentiality. So if you owe the extensive duties to your client, then self-evidently you can't share confidential communications with third parties unless the client consents. And that, I think, is instinctively something every lawyer would understand. Its tricky context is that it also extends beyond the term of the retainer. So if you think about it, you were told by a client certain confidential information, and then maybe 10 years later, the client's still alive, they would still expect you to maintain that confidentiality and never effectively keep their secrets to the grave, as it were, and that the fact that duty of confidentiality continues to exist creates of itself a potential for a type of conflict. So if I could describe this one, and then I'll come on to some pure conflicts of interest. If you know some confidential information about a client, and then you act for another client where that confidential information is relevant, you've then got a problem, because you have a duty to your new client to tell them the facts, or what you know as a lawyer, because you have to be open and have a duty of candor to them. But you have a duty to your pre-existing or previous client to keep those matters confidential. So in those circumstances, it is very difficult for you to act without putting that information at risk. There's a whole, I'll not go into it for the context of this thing, but there's a whole area of law around information barriers and how you might be able to mitigate those risks. But as a general principle, that is an issue to be concerned about. And as an example, there's a Canadian case of the Queen and Spade, where small firm, two partners, one of whom had acted for someone who was charged with manslaughter. She admitted it, but obviously spoke to her solicitors about it, and took them both into her confidence about her position and what she did and how she did it. She was then dealt with, and then another person was charged with murder arising out of the same death. And so at that stage, the firm was proposing to act for the person who was charged with murder, and their previous client was going to be the principal witness, who was going to be tested by defence counsel as part of the trial procedure. So you can see out of that the difficulty is that they already knew, from a solicitor-client relationship in the Canadian context, all about what she thought and did, and yet they couldn't use that confidential information. But they would have to use that confidential information if they were going to act in the best interest of the person who was charged with murder. And of course, the answer was that they just simply couldn't act for both because of that confidentiality issue, and therefore the court prevented them from acting for both parties. Can I then finally, before we come back onto the discussion, just discuss conflicts, what I kind of call pure conflicts. We've talked about the conflict caused by confidential information, but and this does vary. Some of these principles vary from jurisdiction to jurisdiction. Many of the jurisdictions have a provision that you can't act for two clients at the same time whose interests are in conflict. In the States, that obligation extends beyond the two existing retainers, although also in the States it is possible to waive a conflict, whilst in other jurisdictions it's not possible to waive a conflict. So there are nuances between different common law jurisdictions as to how these rules actually work. But the principle, if you think about it, is you have one client, no confidential information involved, but one client where you've got to act in their best interests, but their interests are entirely in conflict with the interests of another client. You can't possibly do it. Another limitation in some jurisdictions is that conflict only needs to be in relation to the same or a related matter. So you could act against one party in relation to, say, a house purchase, and for them in a completely different piece of litigation. But I think that creates commercial issues in terms of whether that client would be happy about it. But the conflict rule obviously has huge practical difficulties, particularly when you start talking about a law firm, because the need to manage what can be several hundred or several thousand people acting for different clients at the same time in relation to different matters, and identifying whether you have a conflict or whether you don't have a conflict is a difficult one. And also sometimes clients have a very shared or have a lot of shared issues, but maybe one or two issues where they do have a conflict. So say 3 or 4 people are investing in the same company. Can you act for all 3 of them? Probably yes, but it might be that one of them, say, is providing the money to the other 2, and that might mean that you have a conflict between the interests of the person who's funding and investing and those who are not actually putting their own money up. So they create huge complex issues in most law firms worldwide as to when you can't act and when you can act. And certainly for present purposes, I think we would be here for the rest of the day if we got into the details of that. And then very quickly to finish off, just an example of where those issues arise was an English disciplinary case where solicitors were fined because they were acting for a client who was selling land to a company owned by them. So self-evidently, they couldn't act for both the client and themselves because their interests were not the same. So that finishes that off. Chris, you're on mute.
We were going to turn to implications of the AIFC, but let me just feed one question from the chat-in from Yelena Volovna, who's a lawyer, who raises a very specific conflict question, which is what happened where the duty to the court and the fiduciary duties to clients are themselves in conflict. Which one would ultimately prevail, which certainly could happen, for example, in some of the confidentiality issues you've been raising?
The duty to the court always takes precedence. So you do. So in fact, the duty of confidentiality, the classic ethical issue, is you're acting for a client who's charged with a crime. The client tells you, well, I did it, but you then have to represent them. Obviously, your duty of confidentiality to the client is such that you can't kind of wander into court, stand up and say, my client's told me he or she did it, and I need to tell you, judge. But what you can't do is then, on behalf of your client, run a defense on the basis that they didn't do it. So, for example, if they had a false alibi that you knew wasn't true, you couldn't run an alibi defense. But what you're perfectly entitled to do is to probe and seek to undermine the prosecution's case without contradicting it, in a sense, with a positive case of your own. So that's probably a sort of a reasonably practical example of where these things aren't necessarily hard or straight lines between the two duties, where you can do certain things but you can't do others in order to keep the right side of the line.
Right, I hope that answers Yelena's question. Shall we turn back to the nasty question about whether all of this gets superseded in a world of legal tech and artificial intelligence? And might need a whole different dimension of regulatory policing, or whether what works well in 20th century law will also work in 21st century.
The principles must be the same. I mean, I think you get into very interesting territory if you start talking about sort of dispute resolution by bot and those sort of things, where how does that work in terms of is that an adversarial process or something different? But the principles which are ultimately the ones that underpin the structure of society in a common law jurisdiction still are there, and the functions of lawyers within it are still the same. The real dilemma that I see is there's a question as to where does the regulation sit. So if the role of the lawyer moves away from being the center of the process and more a bit like the airline pilot that in the days when airlines used to fly frequently, but would put the automatic pilot on and knows vaguely what to do if there's a problem, well, more than vaguely if you're an airline pilot, but generally isn't running it. And if as a lawyer you're buying an off-the-shelf dispute resolution, sort of disclosure discovery software system, and you have no way of knowing actually how it's programmed and how it works to know whether it is effectively undermining your obligations to the client or the court because it's got a certain program within it that means that certain documents are not picked up. I mean, that. So the real dilemma there is does it still rest with the lawyer who has no ability realistically to interrogate the software to the level required to decide whether it has got a flaw in it? Or should we start thinking about regulating the AI and the various other things? Because in fact, that's where the risk is, and that's where we might need to say, well, you can't have this type of program in your AI because it doesn't serve the administration of justice. So it's, and no one's got an answer to it yet, apart from it is a big dilemma as to is the focus in the future going to be on software or lawyers?
And that, of course, isn't just an issue for the legal profession, but it's really encompasses all professional services where decision making to a greater or lesser extent might be outsourced. It's something which doctors are giving quite a lot of thought to at the moment, where firms develop decision-making tools may not always be around to update them in the light of a change in evidence base. And the danger of a perfectly designed tool 3 years ago actually no longer being fit for purpose is really quite high. So there's really as a minimum, a CPD imperative on lawyers to keep up to date with the main developments and to know the weaknesses of decision-making tools as well as their strengths.
Well, indeed. And then the other, one of the peculiar features about lawyer regulation is it's jurisdictional specific. So unlike medicine or indeed accountancy and other professions, which are universal across the world, how you perform an operation, everybody's just trying to find the right way of doing it and the best way of doing it. Whilst each country has its own laws, its own legal system, and therefore everything is shaped in that very small individual basis. And then in certain jurisdictions such as the United States or Canada and Australia, it's not even at sort of national level; it's at state level that the regulation of lawyers takes place. So, how far or how easy is it to have some level of mutual recognition of a piece of AI that's been approved by one regulator that then means that another regulator is able to say to their lawyers, yes, you're all right to use that? I mean, that's what happens in the healthcare and medical sphere around sort of medical devices and things like that, but we just don't have any sense of international legal services regulation. And if the whole purpose of AI and technology is to provide things on an international basis.
So you may actually slightly set yourself up for the next question by another one from Kiwanish. You talked there about regulation necessarily being jurisdiction specific, but would you pick out one jurisdiction as a particular benchmark as the model for ethical code of conduct regulation for the legal profession?
But frankly, no. I mean, I think it's if you start looking at codes of conduct, certainly at the high level around the world, they are very similar, as you from what I've been talking about, you would expect, because they're all addressing fundamentally the same points. But I don't think there's one that I've looked at and thought, wow, this is the gold standard, because quite often they're molded around the particular facts of a certain jurisdiction. I mean, in the States, the American Bar Association has its model code, which is used as a model for most of the state bar associations. But that's, some of it is quite representative in its origin. So it's written by lawyers for lawyers, which means that some of the provisions are perhaps not as extensive as they would have been if written by sort of an independent regulator. So there's lots of different forces going on at local level that I think means it's quite difficult to say, yep, this is absolutely the one that everybody else should adopt.
Although it probably is true that there's at least a little bit more sharing and conversations going on between regulators internationally than perhaps would have been the case 10 or 15 years ago. So there's at least some learning happening between jurisdictions rather than them being totally hermetically sealed.
Well, there is, and there's something called the International Conference of Legal Regulators, where they get together once a year, although not sort of personally this year, where they do share best practice, and needless to say, there are a lot of very common features in every jurisdiction that everybody's wrestling with, and I think there is an increasing recognition that each individual jurisdiction can learn from another jurisdiction. And one of the big issues is external ownership of law firms by non-lawyers, for lack of a better word, which of course you pioneered, Chris, but which is now a matter of sort of widespread debate within many states in the US, has been adopted in part in Australia, and there's quite a lot of looking at the jurisdictions, well, by the jurisdictions that haven't yet done it, at the jurisdictions that are doing it, and trying to learn lessons. And that probably wouldn't have happened 10, 20 years ago.
No, and I think, well, as you know, we've got the scars in the UK of that experience. But what was interesting was something that leads on to actually another question on the chat, where we've been asked to elaborate on the role of professional bodies representing the interests of legal professionals in development and compliance of standards. And in a way, the example you've just made, Ian, illustrates both the opportunities and the problems there, because one feature of what's happened in England and Wales, pressure for it to happen in Scotland as well, is this idea that there is potentially a conflict if professional bodies are the sole owners and policemen of standards, because a professional body also has some incentives to act as a trade union and to put the interests of its own members first ahead of the wider public good. Now, some will do that deliberately when they're involved, for example, in negotiations with government to do things around legal fees. Sometimes it will be a rather more subtle bias. So getting the right balance between practitioners and practitioner bodies who really know the issues that can arise at the coalface, to make sure that legal codes are properly grounded. You'd be a fool to cut them out of considerations, but maybe they are folks who have a big input into setting standards, but are not the ultimate determiner of them. But again, practice on that does vary significantly jurisdiction to jurisdiction.
And it does, and it also comes back to the AI point that certainly some jurisdictions, any legal advice is regulated, and sometimes regulated by lawyers. So not surprisingly, they have an interest in excluding new entrants into the market by virtue of, well, basically self-protection. but how far is that operating in the public interest of having greater access to legal advice by different methods? So I think there's certainly, again in the States, a battle going on between new entrants and the existing legal profession as to where should the balance lie between the lawyers and the non-lawyer providers.
Now, I think David has reappeared on the screen, which must mean we're getting close to the end of the time. I think we've also gone through all the questions on the chat. Ian, let me just ask you one last thing. Would you like to say a little bit to the audience about where the thinking of the panel is getting to in relation to the conduct and design of the regulatory system for the AIFC generally?
Well, that's a heck of a question, Chris. Well, we have been as a panel sort of in existence since the beginning of last year, and we are getting close to the implementation of a regulatory system that aims to be one that raises standards and encourages the development of the AIFC and the legal sector within it, without creating unnecessary barriers to people becoming involved in the AIFC. Say, for example, we're not going to restrict legal practice to only those who are AIFC qualified. It's more, if you want to demonstrate your expertise in AIFC law, then you become regulated, and that in turn means you'll attract more work within the AIFC, and you'll join, as it were, the wider family that way. So we've had a lot of debate around who do you regulate as part of our work, and then I think we are beginning to come on to the formulation of codes, but also the enforceability of those codes, so that if those that don't act in a way that's expected, we've got the ability to enforce against them, and also leading into the work that David's doing, because a legal profession cannot exist unless people are educated, trained through an academy in the process. And so that very much links into recognising people who come up through the academy, giving them, in a sense, a license to practice and to develop and flourish in terms of their practice within the AIFC as it grows and develops.
And I'm hoping the Academy will give us lots more opportunities to tell colleagues about how our thinking's going and what's been put in place. The main message, I think, as chairman of the panel, I'd want to reiterate is we are absolutely looking at ethical models, code models, which enable the reputation of the AIFC to be built. And the more the reputation of the AIFC and legal practice within it is built on a high ethical reputation, the more that will work in its commercial interests as well. I think the one issue all of us are passionate about is to get away from this idea that there's somehow this wonderful business that people would love to pursue, but all this ethical regulation nonsense gets in the way of doing it. What we're trying to do instead is find a model that works to enable the business to work effectively and at a high standard. And that then gets you into a virtuous circle where ethics reinforce good business rather than acting to slow things down. And that's the way you get good outcomes for practitioners and clients alike. And with that rather pompous peroration, I'm afraid, I will stop. And David, just hand the floor back to you to formally wind up.
Thank you very much. First, on behalf of the AIFC Academy of Law, Chris Kenny, Ian Miller, thank you so much for your time, for your insightful comments and your dialogue today. It really has been absolutely phenomenal. From a personal standpoint, as the director of the Academy, I very much look forward to continuing our close relationship with the Advisory Panel on Legal Regulatory Matters. As you rightly mentioned, Chris, toward the end of your conversation, really our work is very similar and it dovetails with each other. As we look to prepare lawyers for practicing here, really the starting point is developing a competencies framework for the knowledge and the skills and the mindset that are required to operate effectively here. And we all have the same focus, that operating effectively means having high standards of ethics, high client commitment standards, and then of course, knowledge and practice skills all go into what we're trying to achieve. And that is to develop a reputation for excellence and to maintain certain standards of quality for practitioners. That helps the global reputation of the AIFC. But also at the end of the day, it comes back to serving the needs of clients. For companies and firms who want to do business here, whether they are financial companies, capital markets companies, construction companies, engineering, and so forth, what really matters is that the legal profession is serving their needs at a very high level of competency. So to the extent that the Academy can provide the learning and development opportunities to enable practitioners to meet those competency standards, well, now that is a rational regulatory system with the right set of values and outcomes that we hope to achieve. So thanks so much for your work on the panel. It's incredibly valuable to the ongoing development of the legal system here. And for that, we're very grateful. So thank you very much to both of you, Chris and Ian, and thanks to our participants. With that, have a great day. Yeah, bye-bye.